bill is referred to the House Committee.
We now resume the second reading debate on the Rural Representative Election Legislation Amendment Bill 2013. Mr. Kwok-him, Chairman of the Bills Committee on the bill, will address the Council on the committee's report. Mr. Kwok-him. Thank you, Mr. Deputy. As Chairman of the Bills Committee on the Rural Representative Election Legislation Amendment Bill 2013, I now report to the Council the deliberations of the Bills Committee. The main objective of the bill is to expand the scope of application of the VREO, the EAC Ordinance, and the ECICO, as well as the subsidiary legislation under these ordinances. This is to make sure that these ordinances and regulations will regulate the Kaifeng representative election in Cheung-chau and Peng-chau in 2015 or after. The Bills Committee held a total of 4 meetings, and at one of its meetings, the Bills Committee met 51 deputations and individuals. Members noted that the proposed regulatory regime for Kaifeng representative elections was based on the regulatory regime for RR elections of existing villages under the VREO, and the VREO will be renamed Rural Representative Election Legislation or Election Ordinance, and there will be a new definition for rural representative in order to cover village representatives and Kaifeng representatives. And there will be a new definition of rural areas in order to cover existing villages, indigenous villages, composite indigenous villages, and market towns. According to the administration, the VR represented or VR election ordinance will continue to retain terms like VRs, IIRs, RRs, and so on and so forth. And then under the village representative election ordinance, the number of indigenous villages and the number of existing villages, the number of IIRs and RRs, and so on and so forth will remain unchanged. The Bills Committee asked the administration whether the proposed areas for the 2 market towns, namely Cheung-chau and Peng-chau, overlapped with any indigenous villages or composite indigenous villages under the VREO. According to the administration, Cheung-chau and Peng-chau did not comprise indigenous villages or composite indigenous villages defined under the VREO. But some deputation and individuals who attended the Bills Committee's meeting claimed that Cheung-chau should be regarded as an indigenous village under the VREO. And Cheung-chau residents should be given the right under the VREO to elect their VRs. The Bills Committee asked the administration to clarify whether Cheung-chau and Peng-chau had already existed in 1898 and whether they were the only 2 market towns which had held Kaifeng rep elections. According to the administration's explanation, the legislative intent of the VREO enacted in 2003 was that there would only be indigenous villages would be incorporated into the VREO if such villages had already existed in the NT in 1898 and such villages had already had a VR system in 1999, and for Cheung-chau and Peng-chau in 1898 they were market towns and they had never had any village representative system. According to the administration, it has taken into account certain records, including the list of established villages and also the list of indigenous villages, the NT block crown list, and also the list of established villages, and so on and so forth. And the Articles of Association of the Cheung-chau Rural Committee has also been studied, and these records do not show that Cheung-chau is an indigenous village. Neither do these records show that there has been a VR system for indigenous villages. Some deputations and individuals are of the view that the Gazette notice in 1899 was evidence that Cheung-chau was a village and had a VR. According to the administration, the Gazette notice was made in accordance or published in accordance with the then local communities ordinance, aiming to divide NT into districts and sub-districts to facilitate administration. The ordinance and the Gazette notice were not related to the VR system, and the committee members of the sub-district listed therein were not VRs. The ordinance was repealed in 1910 because it was found to have no practical effect. The Bills Committee noted that under the Village Representative Election Legislation Miscellaneous Amendments Bill 2009, the then Bills Committee had a detailed discussion on whether there were no IRR seats for Cheung-chau. According to the administration's explanation and the discussion of the Bills Committee in 2009, members noted that the administration and some Cheung-chau residents had different views as to whether Cheung-chau was an indigenous village. And the government and the Cheung-chau residents said they would respectively research into different records. And concerning the proposed regulatory structure for the Kaifeng representative election for Cheung-chau and Peng-chau, according to the administration, Kaifeng representatives in fact have similar functions as those of RRs. In other words, they reflect the views of Cheung-chau and Peng-chau residents on local affairs, and that was why the regulatory structure in the VREO was adopted as the blueprint. And members did not have any special views on the proposal. And concerning the Kaifeng representative election, at the moment the block vote system is adopted. In other words, each elector may vote for a number of candidates not exceeding the number of Kaifeng representatives to be returned at the election concerned. In other words, a maximum of 39 for Cheung-chau and 17 for Peng-chau. Some members expressed support. Other members, however, were concerned that the adoption of the block vote system for the Cheung-chau and Peng-chau Kaifeng representative election would lead to possible domination by some groups of candidates and thus affected the chances of individual candidates winning the elections. According to the administration, the legislative intent was to bring the Kaifeng representative elections under statutory regulation while respecting and retaining as far as possible the existing electoral arrangements that the residents were familiar with, including the eligibility requirements for electors, number of seats, and the voting system. The administration in fact had consulted the Cheung-Chau Rule Committee and the Ping-Chau Rule Committee on the voting system and the other details of the election. And the two rule committees are of the view that the election system that has been in use for a long time should remain unchanged. The Bills Committee asked the administration to consult the two rule committees again on whether the voting system should be changed. And according to the administration, the two rule committees still maintained that Cheung-Chau and Ping-Chau should each be retained as a single constituency, and they objected to any change to the voting system. They were of the view that under the existing election arrangements, there was no unfairness, and in fact there were fair arrangements. For example, the right to nominate, the right to take part in election, and the right to vote. And according to the administration, although electors in the election can vote for up to 39 or 17 candidates, they also have the right to elect fewer than this number, or they may even elect just one candidate. According to the existing voting system, electors can also choose more than one candidate, and so the present voting system can more fully reflect the voting preferences of the voters. And also the present arrangements are credible and representative. Mr. Albert Ho has indicated that he will move a CSA to avoid domination by one single group of candidates. And the CSA seeks to cap the number of choices exercised by each elector in the Cheung-Chau or Ping-Chau Kaifeng representative election. And then Clause 62 of the bill is an amendment to the amount of election expenses VR election regulation. And it is stated under Section 2 that the election expenses that can be incurred by a candidate serving with more than 5,000 voters should not exceed $38,000. Members did not have any views on the proposal, but then some members are worried that if certain candidates are related to certain organizations, or if they are associated with certain organizations, then some candidates may team up in the campaigning work, and there may be unfairness. But according to the administration, the election expense ceiling is governed by the ECICO and the subsidiary legislation. And according to the EAC and the guidelines on election-related activities, candidates or groups of candidates can carry out joint campaigning. For example, they can release joint election advertisements. And so this is an acceptable arrangement. The administration will be moving some CSAs to clarify the wording in certain provisions and to achieve consistency in wording. So, Mr. President, now I will give members my personal views on the bill. The DAB supports the Rural Representative Election Legislation Amendment Bill 2013 and the CSAs to be moved by the administration. I want to say that 12 years ago, in 2009 and on another occasion, the Village Representative Election Bills were tabled in LegCo. And for both bills, I was the chairman of the Bills Committee concerned. And this is the third round of amendments. So I have witnessed the changes that have taken place. And I can see that the name of the bill has been changed from the VREO to the Rural Representative Election Ordinance, so as to more accurately reflect the scope and the scope of the legislation and the geographical areas. This bill seeks to expand the scope of application of the VREO, the EAC Ordinance, and the ECICO, and their subsidiary legislation, so that the regulatory regime can apply to the Kaifeng representative election in Changchao and Pingchao in 2015 or after. This is important to ensure the fairness and justice of the election and to prevent any possible corruption. So I think this piece of legislation represents a major step forward. In the past, because of the absence of such a piece of legislation, concerns were raised, and if there are no amendments to the legislation, there will be problems. For example, those in custody will not be able to cast their votes. So I think this is a major step forward. And in fact, we have had lengthy discussions on election-related legislation in the past. We understand that changes have already taken place. Concerning the chairman and deputy chairman of the Changchao Rural Committee and the Pingchao Rural Committee, like the chairman and deputy chairman of other rural committees, they can become ex officio members of the Kwok-hung. And so it's important that the Kaifeng representative elections in Changchao and Pingchao be carried out and conducted in orderly and systematic manner. This is important, and we should give our support. As the Chinese saying goes, we must have the name, must get the name right and the status right. In 2009, there was a lot of controversy on how to classify Pingchao and Changchao. Should they be regarded as indigenous villages which could have VRs, or should they be regarded as market towns with Kaifeng representatives? The DAB is of the view that a decision must be made on the basis of objective facts. There must be good justifications. For Changchao and Pingchao, they do not satisfy the definition of VR systems based on evidence available. And so, in Pingchao and Changchao, there should only be Kaifeng representative elections. Mr. Deputy, village clusters in the NT have their unique historical background, and these villages have their traditions and also traditional ways of life. Now concerning IIRs, RRs, as well as Kaifong representatives, they all serve to manage local affairs and bring about improvements to the local community and to fight for the well-being of the villagers or the residents. So their functions are similar to those of district councillors. It is just that we serve different areas or districts. And then in this bill, we're looking at the voting system for the Kaifong representative elections for Cheung-chau and Peng-chau. Should the block vote system be kept? Members in this council may have different views concerning a block vote system. And in fact, when I gave a report to the council on behalf of the Bills Committee, I made it very clear that although, for example, in Cheung-chau, there were 37 seats, it did not mean 39 seats. It did not mean that voters or electors had to cast 39 votes. And this is similarly for Peng-chau. The electors do not need to cast 17 votes. So electors can cast 1 to 39 votes in Cheung-chau and 1 to 17 votes in Peng-chau. But some members seem not too clear about the concept. But I think the merit of the block vote system is that electors can freely choose the candidates that they trust. So there was a discussion in the Bills Committee as to whether the block vote system should be kept. At the public hearing, deputations were invited to give their views on the voting system. And most of the deputations present at our meeting expressed support for the block vote system. According to them, for Cheung-chau and Peng-chau, they had always been a single constituency, and the block voting system had been in use. So the DAB is of the view that we should respect the traditions of Cheung-chau and Peng-chau. The electors in Peng-chau and Cheung-chau are already familiar with the voting system. And if Cheung-chau or Peng-chau is divided into smaller constituencies, then that will go against the wishes of the residents. And we must take into account the traditions of Cheung-chau and Peng-chau and the local sentiments. In fact, different places have their different characteristics. Mr. Albert Ho will move a CSA to cap the number of candidates that an elector can vote for in a Kaifong representative election. And I believe that such an arrangement cannot reflect the preferences and sentiments of Chun-yan and Peng-chau. And what is more, the election culture in Cheung-chau and Peng-chau will be changed very substantially, and this is not something that Cheung-chau and Peng-chau residents want to see. And so the DAB will not support Mr. Albert Ho's CSA. Mr. Deputy, these are my remarks. The DAB will support the bill. Thank you.
President, in coming up with the Rural Representative Election Legislation Amendment Bill, what the administration was trying to do was to incorporate in the system this village election system. So initially, we were just referring to indigenous villages, but then subsequently, after the judicial review, it was believed that non-indigenous villages should also be allowed to get involved in matters relating to their own villages. That's why we then introduced the village representative election system. However, in coming up with the original legislation and the subsequent legislation, Cheung-chau and Peng-chau were somehow not included in the election system. The reason being that Cheung-chau and Peng-chau did not adopt this VR election system. They had this KFR election system, the Kaifong representative election system, and in Cheung-chau they had 39 KFR, and then in Peng-chau they had 17. As we all know, after the introduction of the village representative election system and the system was up and running, then some Cheung-chau residents asked, how come in Cheung-chau and Peng-chau, what kind of system do we have? What is this KFR system about? And if it's not included under the government's election system, then how come the district office is involved in arranging the elections? Why is it that for Kaifongs in Peng-chau and Cheung-chau, for the representatives that they have elected, they can also elect among themselves, and then they can join the Cheung-chau and Peng-chau rule committees, and then subsequently they could also have representatives joining the Kok. They asked why, and as a result, somebody filed for a judicial review. If I remember it correctly, that was in 2011. They believe that the administration did not have the right to arrange for such an election because there was no legal basis for that. And they would also like to make a declaration to such an extent that such elections would not be valid. And as a result, the Secretary for Home Affairs interfered, and he said that legislation would be introduced to effect that. That's why the judicial review case did not go ahead. And that's why we had this piece of legislation before us. But then the special characteristic of this bill is not to turn the Peng-chau and Cheung-chau election system into something like the present VR election system. They are not to be aligned with the existing VR election system. Instead, specifically for these two places, we have this tailor-made election system, and a special piece of legislation is being introduced to consolidate or regularize the existing election system. And then the original VR election system, the name would also have to be changed. So instead of being called the VREO, now it's called the Rural Representative Election Ordinance. So in the future, it will be called RREO. In other words, where there are VR election, we have several hundred villages, and then we will have to include two more on top of that, and that is Peng-chau and Cheung-chau. And in these two places, we're going to have the KFR election. So we have to understand this. This is the background to the legislation. So this is a tailor-made system, specifically for Cheung-chau and Peng-chau. And if you ask why we have to tailor-make the system for these two places, that's because up till now, for the KFR election system in these two places, when compared to, well, they are still very much linked to the rule committee election and even the Kok. And then there are no new market towns because Cheung-chau and Peng-chau are being called market towns, so they are not indigenous villages. Well, originally they should have villages. So these two places are the only places with market towns. That's why the problem that we face today is this policy. So do we still accept this? That is to allow these two remaining market towns to continue to be linked to Hung-yi-kok, and we know that the so-called link might entail some constitutional consequence. In other words, they can elect members to join the Hung-yi-kok, and then for Hung-yi-kok under our FC system, they can also elect a representative to join this council. They also have ex-officio members sitting on the district council. So do we still want this? So that's the first issue. Second, many residents call themselves indigenous villages of the Cheung-chau village. They believe that this so-called market town, all right, you just call it by this name. But then in reality, they have this fishing village dating back to 1898. And for a very long time, they had this village representative, and for a long time, they also enjoy the powers and privileges of indigenous villages, and many of these are still in existence and being respected. So for these indigenous villages, most of them are from Wai-chak Hall in Cheung-chau, which is a very famous hall, and actually, Wai-chak Hall can be dated back to before 1898. So they have been given the authority to run Cheung-chau and land on Cheung-chau. As we know, the land has been granted to Wai-chak Tong as the lessee, and then the Tong would in turn grant these leases to the villages. And for the descendants of Wai-chak Tong, they came to this council and expressed their grave discontent, because if you try to put Cheung-chau under this piece of legislation, how come you have totally ignored the existence of indigenous villages groups in Cheung-chau, which is a fact that has been there for more than 100 years. And they've also shown us a lot of information to prove that dating back to 1898, the Cheung-chau fishing village was already in existence. And of course, the most forceful proof was the Gazette dating back to 1899. And we had this local communities ordinance, and the British Hong Kong colonial government drew up the boundaries, and Cheung-chau was drawn up as one of the places, and it was also set out very clearly on the map that this is called the Cheung-chau village. So this is one of the most forceful piece of evidence. And there were also other pieces of documentation, including the Sun-on prefecture history, stating that Cheung-chau was a village. And the third piece of evidence, which we found to be very valid, so we found some ID cards, identity cards, and on that it's written village representative ID card. So without a village, how come you can have a village representative? So you should have called them a market town representative. And how come you are calling them village representative? So these are pieces of evidence which can show that Cheung-chau has long been an indigenous village. And for those who are more familiar with developments, well, they have been exempted from the payment of rates, and also there was special burial arrangements. If you are indigenous villagers from Changchao, you are entitled to certain burial rights. Another thing that they have not been able to enjoy is the small house grants. And the administration also said that, as you can see, all right, in the block lease, their name was not there. So setting that aside for the time being, one of the strongest arguments put forth by the administration was that by 1999, they already scrapped all VR elections, but then in Changchao, the indigenous villagers claimed that the administration had totally ignored their existence, but then they had their own elections. That's why they also had VRs, and some even showed us some history dating back to what had happened, and Mr. Lau Wang Fat might know it better. Well, back in the 50s, the New Territories office and the officer in charge also had a major conflict with the person in charge of Wai Chak Tong, and then the Hong Kong British government then tried to set up this new group, and subsequently it became the Kai Fong Welfare Association, and then they adopted this confrontational approach with the clansmen of Wai Chak Tong, and Wai Chak Tong was then excluded. As we now know, back in the 90s, there was a case in which legislation was introduced to scrap Wai Chak Tong as a lessee. So I have heard the arguments put forth by the deputations at the public hearing held by the Bills Committee. I also listened to their complaints, and I've also read their documentation. I also had meetings with government officials, and of course, I understand that the officials had given their reply. For example, with regard to the local communities ordinance, well, by village they did not actually refer to an indigenous villages, to an indigenous village. Well, if you call that a village, then how come it's not a village? And the local communities ordinance is the best piece of document to show that indeed they had a case there. So I don't think the administration's reply can set the definitive tone on this. As far as I understand it, on the 11th of February 2014, that is this year, the Hung-yi Kok, if I remember it correctly, it was signed by Mr. Lau Wang Fat. So Hung-yi Kok wrote a letter to the administration saying that the Kok was of the view that Changchao in 1898, well, the fact that it was already a village, that's something that the administration should look into. So it shows that you cannot just set the definitive tone or come to a conclusion on the status of Changchao. If there are matters to be dealt with, and if the existing Kai Fong Association, if it's not formed by indigenous villagers, some of them are not even indigenous inhabitants. So in some cases, there aren't even any representatives of the indigenous inhabitants. Then how come you can have a Kai Fong Association not represented by indigenous inhabitants? And of course, they can always seek a judicial review if this is a legal issue. But then, for this council to pass this piece of legislation today, have you respected the spirit of the law? And if you have villages that are inhabited by indigenous inhabitants, should we have enacted the legislation in this manner? Under the system, we should at least have allowed them to elect their own indigenous inhabitants representatives. It doesn't mean that I like this kind of indigenous inhabitants system. I don't really want, not to mention that I'd like to see small house policy being implemented in Changchao. But then all I'm saying is that if there are indigenous inhabitants in Changchao, then your legislation should not have ignored their very existence. That's the reason why I'd like to suggest today that we cannot support this piece of legislation. But of course, I'm also of the view that we should not vote against it, because the original system also need to have a legal basis. That's why I suggest that the DP should abstain from the voting today. And I also think that we should not use the block vote system. I think for any individual, he should be allowed to vote for not more than 1/3 of the members, so that there would be more balanced participation. That's the favorite line of the administration. So nobody should be able to dominate the scene. Thank you. I'll be explaining the further later.
Mr. Chen Hang-pan, Mr. Deputy, concerning the Rural Representative Election Legislation Amendment Bill 2013, the objective is to give a statutory status to the Kaifeng representative elections for Pingchao and Chengchao. This is to ensure that the elections can be conducted in a fair and open manner. I support the bill. The Pingchao and the Chengchao rural committees have Kaifeng representative members. These Kaifeng representatives can reflect the wishes of the residents to the rural committee. At the moment, the Kaifeng representative elections are conducted administratively, and there are 39 and 17 seats respectively. For Chengchao and Pingchao. The district office provides support for such elections, and the district officer is the returning officer. According to the administration, there isn't a statutory basis for the Kaifeng representative elections, and so there are inadequacies, there are operational problems. For example, if someone objects to an entry in the electors register, then the district officer will have to give a ruling. And concerning election petitions, they are also handled by the district officer islands, and there is no independent monitoring. And also the elections are not subject to election legislation, and so people in custody cannot cast their votes. And there is no and also the REO, Immigration Department and Buildings Department are not required by the law to provide information to the REO for the sake of checking the accuracy of the register. So the purpose of the legislation is to expand the application of the VREO, the EAC ordinance, and the ECICO. These ordinances, as well as their subsidiary legislation, will in future apply to the election of rural representatives in 2015 and after. And so I want to say that I support this amendment. The amendment can make us or can ensure that future elections will be more open and fairer. At the moment, Chun-yan and Pingchao adopt the block voting system for their Kaifeng representative elections. Each voter or elector can vote for one or more than one candidate, but of course number of votes can't exceed the number of seats available. So in other words, for Chun-yan voters, they can vote for 1 to 39 Kaifeng representatives or candidates, and in Pingchao 1 to 17. Some are of the view that a block vote system would make it easier for certain groups of candidates to dominate the election, and as a result, it will be more difficult for individual candidates to win the elections. And some have said that Chun-yan and Pingchao should be divided into smaller constituencies to avoid domination by one or a number of groups of candidates. And then some say that the number of votes cast should be limited to a certain percentage of the number of seats available. But then in my view, the voting method has been in place for a long time and has served Changchun and Pingchao well. We should not change the arrangements lightly. All along, Changchun and Pingchao has been a single constituency. And Changchun and Pingchao are small communities only. In fact, the residents and the electors know each other very well. They know the candidates, their background, their track record, and voters cast their vote on the basis of the experience, expertise, and dedication of the candidates. It is said that candidates can carry out joint campaigning, but then at the same time, electors can exercise free choice. They need not choose all those in a single group carrying out joint campaigning. They may only choose 1 or 2 members in this group. So electors can objectively assess the character and ability of the candidates and choose the candidates that they like. And also, Changchun and Pingchao are integrated communities. The interests of the residents are interconnected and indivisible. As you know, in Changchun, there are only a few streets. And so if one part of the street belongs to one constituency and another part of the street belongs to another constituency, then there will be poor coordination. So if, say, Changchun and Pingchao are divided into smaller constituencies, then a Kai-fong representative may only represent one street or half of a street, and that would affect the overall development of Changchun and Pingchao. For example, for Changchun North and Changchun South, the population is rather scattered, and so it is not good to divide Changchun into small constituencies. And it will be very difficult for the Changchun Rural Committee to play a coordinating role. So under the present system, the residents enjoy the fair right to vote, to nominate candidates, and to take part in the elections. And so as the block vote system has served Changchun and Pingchao well, it should not be changed. And some are of the view that the name of the bill should be Village Representative and Rural Representative Election Legislation Amendment Bill. And this is to reaffirm the VR system. Now, the VREO provides for the election of over 1,000 representatives, village representatives for the villages in the NT. And now, under this bill, the Kai-fong representative elections are brought under statutory control. And the name of the bill now reads Rural Representative Election Legislation Amendment Bill. But then some are worried that this name may dwarf the role of VRs. They in fact constitute the majority under this bill. In fact, VRs have been elected many times in history, and also the term VR is very clear. The meaning is clearer than that of the term rural representative, because people may not know exactly what rural representative refers to. And so in the amendment bill, or in this bill, I hope that the administration can call the bill Village Representative and Rural Representative Election Legislation Bill in order to emphasize the role and the status of VRs. All in all, I support the bill. So in other words, I want the Kai-fung representative election to be brought under statutory control, and also the voting method should be retained. And I hope that the bill should be called the Village Representative and Rural Representative Election Bill. Thank you.
Mr. Ma Fung-kwok. Mr. President, I speak in support of the amendments in the Rural Representative Election Legislation Amendment Bill 2013. In the past, in the KFR elections of Changchao and Pangchao, there's no statutory basis. So they followed the established practices. Thus, they had encountered a great deal of problems. In order to regularize the two elections, the amendments are reasonable. And through this bill, there'll be a statutory status given to the elected representatives so as to serve the Kai-fungs. During the period of scrutiny, a number of issues were of particular concern to members. In particular, whether or not Changchao and Pangchao should be divided into a number of constituencies in order to abolish the single constituency system, and whether there should be a one-person, one-vote system to replace the block vote system. I think the first suggestion is difficult to implement. Changchao and Pangchao respectively of 8,600 and 3,100 KFRs to represent the residents. In the past elections, there were only 2,505 and 1,705 voters respectively, 29% and 57% respectively. If there are to be smaller constituencies, there will be even fewer electors. And then candidates will only need a small number of votes in order to get elected. Therefore, the degree of recognition and representation will be doubted. In fact, the two types of elections are not very different. There's not much uniqueness. So I am inclined to have one single constituency. As for the other suggestion, that is to adopt the block vote system to replace the other electoral systems, I don't see any justifications and reasons for adopting that suggestion, that is to adopt the block vote system. Mr. Albert Ho wants to restrict for Changchao and Pangchao elections the number of KFRs to be elected, and he would like to set percentages. I understand that Mr. Ho would like to improve the electoral systems, but then during the scrutiny period, more stakeholders are in favor of the existing arrangements. That is, in the Changchao and Pangchao KFR elections, at most 13, 9, and 17 candidates respectively should be elected and returned. Of course, we should give consideration to the views of the stakeholders. There are pros and cons to the electoral systems, but in future there's still room for further assessment. We should take the opportunity of this bills to establish a statutory basis for these elections. So I support the administration's amendments. Mr. Albert Chan, Mr. Deputy, in dealing with the scrutiny of this bill, actually we are dealing with some historical legacy. So we try to resolve some of these problems, but then the more we try to deal with that, the more problems have surfaced. So some of the problems have not been clarified by the introduction of this bill. Instead, it has given rise to new disputes and generated some new problems. Well, dating back to the 1990s, under the colonial era, well, on the issue of one-way chak tong, we tried to deal with that by way of legislation. So Changchao, with regard to block lease and also the control of the block lease, and one-way chak tong, became the lessee of the block lease, and its status was changed as a result of that amendment bill, and that also in turn affected the residents' relationship there, in particular when it comes to land management. And I was the deputy chairman of the Bills Committee responsible for scrutinizing this bill, and Tang Xiu-tong was the chairman, and only 2 of the members of the Bills Committee are still here today in this council. With regard to Wong Wai-chuk-tong, well, it has a direct and necessary relationship with today's bill that is presented before us. With regard to the election system there, well, some members might have some difficulty understanding the wording and also the spirit. Well, with regard to the indigenous inhabitants election, our understanding might not be entirely correct. Well, looking at the indigenous inhabitants organization before 1898 in the new territories, so long as you have a community, then to a certain extent it's already treated as an indigenous inhabitants group. Well, when it comes to market towns like Taipo market and so on, is somewhat different, because when you describe a place as a market town, then you're actually talking about people doing or engaging in some hawking activities in the morning, and then they'd go back to their homes in the evening. And that would not constitute a village where villagers would be living together in the same village. But then sometimes market towns could also become a place of inhabitation. If that market town before 1898 already formed themselves into a community, so you can actually say that this market town already became a village of indigenous inhabitants. Earlier on, when we scrutinized another bill on rural election, I successfully managed to do this, like what the DAB always claimed it was able to do. So nobody would have believed that Albert Chen had managed to get indigenous inhabitants to go into that village, and I was able to convince many members of this council and officials so that Yuen Long Market, which is right next to the Yuen Long West Rail Station, is a very unique and special market town, and it was also included as one of the indigenous villages under the rural election system. So it became one of the 100 or so indigenous villages. So it's also called Yuen Long Market Towns. So when you criticize Cheung Chau for not being a village per se, I think the arguments are similar. Well, Cheung Chau and Wui Wo are no different. Wui Wo is very similar to Cheung Chau. They also have many streets and villages, and then right in the next lane you have another village. You have different representatives. You also have formal village setups. So if you say that alright, it cannot be treated as an independent village, well, this is happening all over the place in the new territories. So just a lane across the street, you have another village. So I believe that in Yuen Long they also have many such villages, and if you go to Shangshui, Taipo, Shatin, or even Puyo is the same. Alright, right next to Puyo in Tai Wai, and then you have another village representative across the road. So you talk about geographical distance. Alright, the location is slightly different, and therefore it cannot be regarded as a village. This is not in line with what's happening on the ground. Coming back to Cheung Chau, alright, I think it was in 1995 or 96, the then LegCo enacted a piece of legislation scrapping the status of Wong Wai-chuk-tong as the lessee of a block lease, because Wong Wai-chuk-tong also had different streets, because they had their own connections, and they had their own representative system. They also had persons in charge. So in many villages, they also had the system in place. All right, they had different communities, and they also elected the representatives by way of election. But then they did not use those names. They used the name Tong. So they were there before 1898. They also had the formal system. They also had persons in charge. They also had formal powers. So their powers were even more extensive than those of indigenous inhabitants organizations, because in the Qing dynasty, well, the person who had the ultimate say in Wai Chak Tong would be a lot stronger than those persons in charge of other indigenous villages organizations in the new territories. That's why when the Wai Chak Tong legislation was passed, and of course Wai Chak Tong was staunchly against the amendment bill that was enacted, and they did not say that given the fact that my status as a lessee of the block lease was scrapped, I should have been incorporated in the indigenous villages set up. That would have been a lot more fair. But then their descendants did not raise this themselves back then. They were of the view that they were Chiang Chau's legitimate indigenous villages. They were actually the landlord of Chiang Chau, because in the Qing dynasty, because of this special endowment by the emperor, they had this special status. But then if you look at this from the perspective of the rural representative election system, and also if you look at the original intention of having this indigenous inhabitants system, all right, the people's power is against the privileges enjoyed by indigenous villages. We are against small house policy. But then if you just look at it from the principle of the law, being fair, just, and you have to respect history, then Chiang Chau should have two groups of people. Because the VR system also had indigenous villages organizations and non-indigenous villages organization. And then in Chiang Chau, you have the rule committee there. I believe that overwhelming majority of them were not indigenous villages who had inhabited the place before 1898. That's why they are not representatives of indigenous inhabitants. And for those who are genuine indigenous inhabitants in Chiang Chau, they are descendants of Wai Chak Tong. So Wai Chak Tong's descendants should be 100% indigenous inhabitants. They are descendants of indigenous inhabitants. They had records to show their ancestral connections, and they've also reached an agreement with the HAD with regard to what's meant by indigenous inhabitants. They also had formal representatives returned by election, and before the enactment of this of the piece of legislation in this council, they had already been there. And in the early 1990s and also in 1898, there were proof to show that they had some form of election system to elect the representatives of Wai Chak Tong. So if you look at it from the angle of history, then Chiang Chau's Wai Chak Tong, if you look at its organization and mode of operation, when compared to many so-called indigenous villages or village representatives in the new territories, well, in terms of the election system, the element of election or representativeness is even stronger. Because if you look at the new territories, many have gone through relocations and so on, and therefore some of the existing indigenous villages are not the same as those that had inhabited those places before 1898. But then if you look at Chiang Chau, this group of residents, well, their ancestors were already here before 1898. So how come they are not treated as indigenous inhabitants? So the amendment bill has not been able to deal with this historical problem, and based on that, this is not fair and just. And to these genuine indigenous inhabitants, it's not fair. Therefore, people's power will will vote against the second reading of this bill. As I discussed with Mr. Lau Wong-fat earlier on Wai Chak Tong and Cheung Chau's characteristics, I believe that Hung Yi-kok and Wai Chak Tong's descendants should have a meeting as soon as possible, because we understand that if you want to convince the HA Bureau to agree that Wai Chak Tong's representatives should become indigenous residents representatives, you will have to you will have to convince the Hung Yi-kok first. But then the problem is, overwhelming majority of these so-called rural representatives are actually at loggerheads with Wai Chak Tong politically. They are at opposite ends. So if I am a rural representative or village representative of Cheung Chau, even though I'm not a descendant of Wai Chak Tong, all right, I've become the feudal lord. All right, you're trying to replace me and snatch me of my power, and you're actually trying to go back to what's been happening before the 1990s. So you're asking them to abandon their power. I think it's just a pipe dream. And majority of these people are the allies of DAB, and they have the DAB, which is the biggest political party in this council. Of course, you know my political affiliation, and therefore I'll have to distance myself from you. So this is a political issue. And this group of people in Cheung Chau, these are the local leaders in Cheung Chau, and they have the DAB as their backup. And every year, they have also been heavily involved in DAB's election campaign. So this is about mutual or reciprocal coverage politically for one another. So who can deny what I said just now? There is a lot of documentary proof to show that Wai Chak Tong should have been treated as indigenous inhabitants is indisputable. Yes, in some documents they have the wording village, but then the fact that it had been in existence as a community is indisputable. Therefore, I believe that with the support of the DAB and with the DAB trying to protect them, well, for Wai Chak Tong to get justice, it will be extremely difficult, if at all possible. That's why I hope that for the pro-establishment camp who are not from the DAB, you will have to respect history. This is a fact. As I said at the beginning, we are against the setup of indigenous inhabitants. They should not have enjoyed any privilege any privilege after 1997. There should be no distinction between indigenous or non-indigenous villages. But then you will have to respect history. You will also have to respect the relations amongst the various parties, and therefore we should vote against the second reading of this bill, so that they would not be able to implement the bill, and then that would force the Home Affairs Bureau to restart the negotiation so that we can serve justice on history, and then the indigenous villages in Cheung Chau will be given justice.
Does any other member wish to speak? Mr. Leung Kwok-hung. Mr. Deputy. I have met the Cheung Chau residents at the complaints division, but I want to say that I seldom go to Cheung Chau. For the rural committees and the interests of the indigenous villagers, we've said many times that such benefits or privileges should be scrapped. Then look at how many votes the rural forces have in the small circle elections. So do you think they will be willing to give up their privileges? Concerning bills passed by this council, can they be subject to a judicial review? The answer is yes. Now, for example, I have gone to court because of the president's decision to end the filibustering. So maybe someone will seek a judicial review of this piece of legislation. Now, I sought a judicial review of the interception of communication legislation at the time, and then I won. Chang Tak-shing is here. He's very busy because $60 million need to be spent on Project Phoenix. But then I have to try to chase for wages in arrears for certain people in the football sector. But I understand you are very busy. You have to entertain many people. Now, some people just say that what they say is true. So it's like the interpretation of Article 45 of the Basic Law. My interpretation is the right one, some people say. So now, it was said that Changsha was called a village. So it was a village which was recognized as a village, but then this village can't hold a VR election. So I asked the official whether it could no longer hold a VR election because it was not called a village, and as a result there was never a VR election, and so this place couldn't be a village. So concerning the Gazette notice in 1898, was that village really a village? And then second, I want to ask this question. When the administration has a dispute with resident organizations, what is the approach adopted by the administration? So the governor, the district office, were responsible for the administration of these places. And as chaos had arisen, who would be responsible? The administration or those being ruled? Was the Wong Wai Chak Tong election a VR election? And was that place a village? Or was it a fishing village? Now, if you go to Mui Wo, you see only concrete, and yet a street is regarded as a village. So in 1898, Chanchao was regarded as a fishing village, not a market. And then, or maybe it was a market town with some villages nearby. And now this administration is telling members that I don't care. I'm not going to deal with this issue anymore. So people said Chongqing used to be a village, and the elections that took place were in fact village elections. And the indigenous villager organization is still here. But now you are saying that you want the bill to be passed and you want Legco to be the rubber stamp, and I won't rubber stamp this bill because you haven't sorted out all the relevant issues. Now, in fact, with small circle elections, the distribution of interest is bound to be like this. People who can exercise influence, or groups that can exercise influence in a small circle elections can get the benefits. Now, I don't know people from the Wai-Chak-tong, and I don't really think they have those powers. But I can't say that the legal justifications put forward by Wai-Chak-tong and the residents are wrong. I don't know people, the Wai-Chak-tong people, and you know, people in the rural area do not like me. So if I go to Chun-yan, maybe they will criticize me. But in this case, I really can't vote in support of the administration, and I think the administration should start some discussions with the stakeholders in Changchao. There are these people who claim that they are indigenous villages, and they can fulfill the administration's definitions concerning VRs, VR elections. So I think it's important that we all act in a fair manner. I hope that members will vote against the bill. This is to force the administration to return to the negotiating table with Changchao residents and Wai-Chak-tong. Why am I doing this? I hope that members will consider this very carefully. I think it's really bad to have bills passed in this council being struck down after judicial reviews. And I think the secretary and his colleagues do not reason. You may raise 1,000 questions, 100 queries. They do not really answer your questions and queries. They just repeat their standard or model answers. It's like implementing universal suffrage. I don't care how you think. I just say what I want to say. Let's talk to implement universal suffrage. Again, the government is fooling us. I hope that members will vote against the bill. Thank you.
Dr. Kenneth Chan. Thank you, Mr. Deputy. I'm also a member of the Bills Committee. At the same time, I'm the Deputy Chairman of the Home Affairs Panel. Just now, I dug up the records and see that in July 2013, there was a paper which went to that panel. Why did I have to dig up these papers? Because for the first time in my life, I learned of this place known as Wai-Chak-tong. All of them went to our panel. The chairman was there. There are so many Wongs. They took turn to speak. I found that strange. In July 2013, in the administration's paper for the panel, there's no mention about this issue. There's no reminder for our colleagues in the Home Affairs panel that there had been such a conflict. Or perhaps I was a new member. Here in this chamber, there were older members who knew the incident, like Mr. Albert Ho, Mr. Albert Chan, and Mr. Kwok-him. They immediately knew what happened. So in the panel, I could solely rely on the administration's information. Prima facie, that's something very simple. We're talking about Chang Chao and Peng Chao only. That is, whether or not their elections should be regulated by the bill as well. So we should do something. We should not just resort to administrative measures to regulate elections. Prima facie is simple, is straightforward, is in compliance with public expectations about a good election. That is verification of the qualifications of the electors, the qualifications of the candidates, capping electoral expenses, problems, particularly legal issues encountered in elections, etc., etc. Government departments should ensure that there's openness, justice, and fairness in the elections of Chang Chao and Peng Chao. So prima facie, there are no major problems. The government told us that it took time for them to study further details because Chang Chao and Peng Chao were different, so they are not included in the last exercise. So this time, they're trying to do something. Prima facie, the government is doing something now. But I found it strange that so many colleagues put up queries about whether or not their indigenous villagers, IVs, on Peng Chao and Chang Chao, were they not recognized by the government, such that repeatedly they came to the LegCo, not just to the public hearings of the Bills Committee, they also fetched individual members. They went to the Complaints Division to repeat their queries and doubts. Honestly speaking, Mr. Deputy, I thought they did not have any avenue to air their grievances. They've always been excluded. They lost those rights that they had been enjoying for a long time, and their identity never been seriously considered. So in handling electoral methods and systems, they're very worried about the recognition of their identity and status, which would become even more difficult after the passing of the bill. So they came to us to ask us not to enact the bill. Otherwise, they would lose opportunities to put up their aspirations as indigenous villagers. Here, where LegCo members, we try to have meetings with the government to handle the issue. Honestly speaking, at the end of the day, they might resort to litigations in front of the court, the judicial system, in order to resolve their grievances. All along, we asked the administration to explain why it had not considered the status of indigenous villagers from Wai Chak-tong on Chang Chao. A lot of documents are involved. Honestly speaking, the documents were only repeating and repeating certain issues without addressing the issues. And these Chang Chao villagers dug up their archives to find out papers in black and white to persuade LegCo members such that we could stop for a while and think about the issue. What did they do then? Originally, my understanding was that this bill is to regularize certain electoral arrangements such that they could be regulated by law. That sounded simple. The only consideration is, as Mr. Albert Ho said, whether we should have proportional representation or a block vote system. Well, that discussion was very meaningful also. I'll come to that later. So the government has very heavy duties about this. Looking back at July 2013, when the Home Affairs Panel discussed the issue, or even before that, honestly speaking, some government officials asked me out privately to discuss the issues. But then I did not receive messages to that end. No messages to that end. Is it that the government intentionally neglected those arguments? The government only told us that we're talking about regulation of electoral arrangements only. But then, Mr. Deputy, that's not correct. Just imagine, the work of the LegCo is not to be led by the music of the government. We shouldn't stop at that. The government should not be as ignorant and naive to think that members of the public won't come here to air their views, to state their position in order to gain our support, such that their statutory rights, status and identity, etc., could be addressed. So thinking back, I'm very angry because intentionally or unintentionally, the government skipped those aspects. The government led us to think of just one issue. Was the government misleading the panel and the LegCo? If we had discussions back then, there might have been room for discussion such that we could work out certain solutions. We should not drag this on. We can think of other solutions. We need not bundle those issues with this bill. But the attitude of the government up to now is that the government had not told us anything extra. The government just wanted us to pass this bill. But we would like to handle the Wai-hing dispute in relation to the status of the residents. As for this paper submitted by the government to the HA panel in July 2013, there's a paragraph about public consultation, which is applicable to all. The government said that parties have been consulted, Fung-kwok, the Home Affairs panel, etc. Those Kai-fongs who came to the public hearing of the panel considered that they had not been consulted. Their right to know had been exploited. They came so late because throughout the process, their intention was not drawn to this issue. Can we blame them? If these representative bodies, rural committees or Kwok-him, did not proactively fetch these villagers, if you live on Changchao, you know these villagers all along, their requests or grievances, if you like. That's why they came here to argue with the administration. And how did the Home Affairs Department conduct the public consultation? According to that paper, they only consulted the elders in the rural committees or the Kwok, only their leaders. Such consultation would, of course, result in problems. So this issue has disturbed the LegCo and the panel. Originally, this bill was a good thing. But now it's very difficult for us to move on. As for electoral systems, when the BC discussed the bill, we had some arguments as well. I was particularly concerned about the block vote system. Very strange. If not for the Wai-hing incident, things had proceeded well. Well, we asked the government, they said there's no information. We asked about the money spent, what groups had been involved, what stakeholders or parties had participated, etc. There's no answer. Of course, it's good to regularize the election. But as a result, would we come up with syndicates to exclude certain independent candidates or supporters of these candidates? Now, this is something very real. All along, the block vote system has generated such problems. And the elders always said, oh no, there are no such problems. Some independent candidates did win, in fact only one. We asked how independent that was. Oh, in fact, there were identification methods for certain candidates. The electioneers wore the same color of clothing. So we may come up with bullies. There may be problems for electoral expenses, $20,000 per candidates, but if you can pool certain candidates together, you may get up to millions of dollars for your elections. Any candidate will encounter such problems. Of course, you'll say at the end of the day it's for the electors to decide. If there are just a few candidates, from, say, a certain stakeholder, don't vote for them. Vote for the independent candidates. But under the block vote system, candidates from syndicates, plural number, can mobilize huge resources for electoral engineering to combat a minority of independent candidates or minority groups. And of course, we have to consider the circumstances of the village concerned. I agree. In the panel and in the Bills Committee, I did consider the actual circumstances of the villages. Well, theoretically, they're not saying that so long if you adopt this electoral system, something grand and great would result, and all problems can be ironed out. I really want a review from the government. Even if the government's proposal this time is passed, the government should collect statistics and data on Chun-yan and Pang-chao elections with the block vote system, whether or not problems that we're so concerned about did emerge, like monopoly, such that a minority of independent candidates and electors had been excluded. Of course, we don't have evidence now, but if the government can collect status and data, then in future we'll have better and stronger reasons for mobilizing electoral reform. As a start, we must seriously consider Mr. Albert Ho's suggestions. Why? At the beginning, I mentioned the residents belonging to Wai-hing. I asked why they did not stand for election, why they felt they're excluded, why they did not become Kaifeng representatives, why didn't they join committees? They said they're the minority on Chang-chao. So they admitted fate, because even if they had participated in elections, there's no chance for them to win. So the block vote system will just be the same as the existing system. So they felt helpless. They strongly felt helpless. To the officials, if they know the Wai-hing, they may say that they're very fierce, they're very rich, with a lot of resources. They're not tame people. But on this issue, we don't need to consider whether or not they're tame people, whether they are particularly rich. They're blah, blah, blah. In an election, it's a matter of counting of votes. It's one person, one vote. It's a head count. If in a certain place, a group of people is always the minority, under the block vote system, if they can find a room for participation to enter committees and the Hung-yi cook, then they need not think about anything else. The problems cannot be solved. Therefore, in this exercise, we have to consider, number one, recently we studied and discussed Wai-hing and Chang-chao, whether or not they have the identity of indigenous villages or indigenous residents. The government should seriously consider whether anything more can be done to address their aspirations. Otherwise, they would feel all the more that they had been excluded. So I hope members can support Mr. Albert Ho's amendment. Then there will be a chance to protect Wai-hing and the minority of independent Chang-chao residents. Thank you.
Dr. K.K. Kwok, Mr. Deputy, I speak in support of Mr. Albert Ho's amendment. Not too long ago, a group of Chang-chao residents came to a complaint division meeting, and I was also the duty roster member, and I had a lengthy discussion with them. I believe what I have to say is, up till now, it's been many years after the reunification, there are still some Chang-chao residents enjoying certain privileges. I'd like to say that I'm against that. And the administration did promise that it would change and reform this system whereby indigenous villages would enjoy certain privileges which had no recognition at all amongst the residents. And now Chun-yin also said during his election campaign that he would review and change this distorted system, and I believe that this pledge should still be there. And just yesterday, when C.Y. Leung eloquently and shamelessly said that he felt very good about his administration, and he said that most of his policy pledges had been honored and delivered, but then he's dividing Hong Kong into two communities where there are indigenous villages and non-indigenous residents. He did not dare to face up to these issues, and still he tried to cover up certain interests, and he tried to meet up with people with certain influence, and these blemishes, if he did not, or if he doesn't work on that, these blemishes will continue to be there. Here we are faced with a situation whereby these are some insiders. Of course, Wong Wai-chak-tong is not an insider. That's why it will have no luck at all. And even if we pass the amendment moved by Mr. Albert Ho, if in the fortunate event that is passed, I also do not see how it could have any chance of winning anything at all, because if you look at the existing setup in societies, if you do not have some vested interest, then how can they win an election? But then why have they bothered to come forward to state their case? That's because even under a distorted system, they just like to get some justice. So that's all they are asking for. So all they are hoping is that the administration could see that historically they should enjoy this status. Well, in 1898, they've shown us a lot of documents which could be dated back to more than a century ago, and even in government's documents, it's already stated that they should enjoy the status as a village. So it's written in black and white, is in historical documents. So what they are most unhappy with is in the process, well, the island's district office and also some government officials have totally ignored what they have asked for in no uncertain terms, and they have never been allowed a chance to state their case very clearly. That's why, more than once, they tried to knock on the doors of this council, asking that government officials should meet with them, and they wanted us to ask the officials to meet up with them. So how come the district office or the Home Affairs Department, they should have acted on behalf of the residents to introduce reforms? How come you have failed to do that? The reason why you have introduced this legislation, that's because, well, some of the abnormalities, you're trying to regularize them so that they would be dealt with in a more proper manner. But then, in the process, you have a group of people who have lived in Changchao for more than a century, and they've already clearly stated their case and proved their historical status, and yet their views have never been respected, and they have not been recognized as indigenous residents there, and they've already made it clear that they have felt most frustrated and disappointed in this process. Of course, I don't want them to resort to what the administration has been criticizing them for. You should not resort to actions to challenge the government's decision. But then in order to defend their position, they have no alternative but to resort to this kind of action. If the administration had been able to have an open mind and if the administration had been more objective in discussing with them this amendment bill, so that some of the queries that they have raised could be addressed in the bill, then they would not have resorted to this. They would not have to beg the administration or the government officials to meet with them up to this very late stage. So if the administration insists on going its way, then I think we will only end up in a lose-lose situation, and we will not be able to address the grievance of some of these residents. In the end, they would only express their discontent about the administration's differential treatment, and their grievances would only go up. So why do you have to do this? So for the block vote system, basically it's a very bizarre type of voting system. I remember in the nominating committee for the election of the chief executive, they have adopted this block vote system. This is most uncivilized. This is not a good system at all. How come you have to adopt this kind of system? Why have you not encouraged more competition? Why have you not allowed them to represent the voices of the people so that there can be more competition, so that different voices can also be heard. Well, some views are very peculiar. Well, some say that, Ping Chau, Chiang Chau are just an outlying island. All right, Hong Kong Island is also an island, and then Lemma Island is also an island. So why can't we just put together all the islands? Because we are all called islands. Can that be done? No, of course not. Because we have district administration. The reason why we have to respect the uniqueness of individual communities. Well, how can Ping Chau be grouped together with Chiang Chau? I don't know what kind of logic they have followed. Yes, it's true that for elections based on the interests or privileges of indigenous inhabitants, of course, we are all against that. And therefore, the administration must come up with a corresponding system that will address these problems, including the small house policy. Let's not forget that we are talking about close to 1,000 hectares of land, and yet, because we have to meet the demands of this absolutely unfair small house policy, yes, some people are still living in subdivided flats, and they are living in appalling conditions, and yet the administration is still saying that it has to respect this small house policy. And now, you are not trying to put things right. This is a distorted, abnormal, and outdated system. It's an unreasonable and unfair system. And now you're trying to put things right by regularizing this election system, and yet you are entrenching this unfair system, and you're actually generating more grievances and discontent. So what's the purpose of doing it in the first place? Well, just now we have heard that with regard to people with influence or people with clout, so you are actually adopting a different approach when it comes to members from a certain political party, and then for descendants from Wai Chak Tong, if they had anyone else to help them, then they would not have resorted to seek help from the pan-democrats. Because in this council, we still have FC or functional constituencies. Sorry, Mr. Albert Ho is also aware that we are in the minority, even though we represent the majority view in the community. But then we dare not promise that we would be able to put things right, including enacting the amendment moved by Mr. Albert Ho, because we all know that under the current system, however outrageous things that the administration might be doing, in the end, the pro-establishment camp would always make sure that whatever they propose can get through this council. This is a fact. This is a reality. But then the administration needs not do that. You could have done it in a more graceful manner. You could have done it in a more elegant way. You could have taken on board the views of the disadvantaged and also the minority group. All right, I'm not referring to their means. They might be very well off, but then, however well off they might be, they would not be better off than the rule committee people. So your wealth or your means would be nothing when compared to them. We are talking about land interest. Wai Chak Tong is just no comparison to them. We're talking about tens of billions of dollars of interest in terms of land in the new territories. So on this occasion, this might be the same as other policies and papers. The administration might be able to get it through this council. But then what I'd like to say is, if you insist on doing this, then the distorted policies and systems will become even more distorted. Yes, what might be helpful is that for these outrageous things, if you insist on doing that, then the public will be even more aware of this. The administration is there to protect such distorted systems so it can do outrageous things. You're trying to favor certain sectors, so I don't know what's going to happen. Well, these are things that have been there for many years. These are historical legacy. and you will have to resolve them, because if you do not resolve these problems, then Hong Kong cannot move ahead. So we have been working very hard, and yet we have not been able to change the situation. The administration is in possession of a lot of land, and yet you have not been able to address the problems faced by the people. All right, you have to demolish homes, and you have to do many things. You're actually trying to destroy the environment, and yet what you've been doing, well, you dare not touch these so-called vested interests. And if you do not protect them, then why on earth can they still hang on to their vested interests? And the administration is actually protecting and defending such distorted systems. These are my remarks. I support Mr. Albert Ho's amendment. Thank you.
Mr. Andrew Leung. President, the main purpose of the Rural Representative Election Legislation Amendment Bill 2013 is to apply to the Kaifeng representative elections, the EAC ordinance, the ECICO and the VREO. So in future, Kaifeng representative elections will be subject to the monitoring of the EAC. Now, in fact, Kaifeng representative elections were held once every 4 years, but then as the elections are not under statutory control, certain problems have been encountered, and so we support the arrangements. We support the proposed improvements to the election system. I would like to state my views on the bill so that the future elections can better suit the interests and the needs of the voters. Now, according to the last Cheung Chau Kaifeng representative election, the number of registered electors was 8,579. And in Peng Chau, the number was 3,068, 2.8. But then in Cheung Chau, the voter turnover rate was 29.2% only, while for Peng Chau it was 56.9%. According to some of the voters, the voting hours were not very convenient. For example, for the 2010 Cheung Chau Kaifeng representative election, the election hours or voting hours were from 9 to 4, and some of the electors were of the view that the voting hours were too short, too inconvenient, especially, and this was especially the case for electors who had to go work in the urban area. They were not able to cast their votes before they went to work, nor could they cast their votes after work, and as a result the voter turnover rate was rather low, and so the opening hours of the polling stations should be revised so as to allow more electors to cast their vote. And I think perhaps reference should be made to the opening hours of polling stations of LegCo and District Council elections. In other words, the opening hours should be 7:30 a.m. to 10:30 p.m. And then for the Cheung Chau and Peng Chau Kaifeng representative elections, the block voting system is used. In other words, an elector can choose more than one candidate. We are of the view that this voting method has been serving the two places well for many years. This is an established voting method, and so we are of the view that this voting system should be maintained. And concerning Mr. Albert Ho's amendment for capping the number of candidates that an elector can choose, then there may be problems. Say, for example, if there are only 5 seats, then an elector can only choose one candidate. Or if the electors can only cast a number of votes that's only 1/3 of the total number of seats available, there will be problems. Now, in fact, the voters on Changchun and Pengchao know the voting system very well. They know that they can vote for 1 to 39 candidates or 1 to 17 candidates, and so if this voting system really has to be changed, then there must be sufficient consultation beforehand. So I support the second reading of the bill. Thank you.
If not, I now call upon the Secretary for Home Affairs to reply. Secretary? Mr. President, first of all, I have to thank the Chairman of the Bills Committee, Mr. Kwok-him, as well as members for their hard work, such that the scrutiny work could be smoothly completed. I'd also like to thank members of the Bills Committee for supporting the resumption of the second reading debate on the Rural Representative Election Legislation Amendment Bill 2013. I'd also like to thank those members who spoke just now for their remarks. The purpose of the bill is to legislate to regulate the Changchao and Pengchao Kaifong representatives KFR's elections that have had a long history. The village representatives VR elections have, since 2003, been conducted in accordance with the Village Representative Election Ordinance Cap 576 VREO to return 2 types of VRs, namely the RRs, the residents' representatives, and the IIRs, the indigenous inhabitants' representatives. Up to now, there are 3 statute-based general VR elections. Under the supervision of the Electoral Affairs Commission, EAC, and the Regulation of Elections, Corrupt and Illegal Conduct Ordinance, ECICO. Changchao and Pengchao were market towns that had been in existence since 1898. Since the 1950s and the 1960s, when rural committees RCs were set up, there had been KFR elections. And the KFR and VR members were rural committee members, and KFR's duties and functions are similar to those of RRs in VR elections, representing the opinion of Changchao and Pengchao residents in district affairs, but their KFRs are not regulated by law. The Village Representative Election Ordinance and related laws regulate the registration of electors, nomination of candidates, conduct of elections, handling of electoral petitions, refer to the RRs, and the district officer and the court, respectively, independently handled such matters. Any irregularities are regulated by the subsidiary legislation under the EACO and the ECICO, that is the Ordinance, and the Electoral Affairs Commission Ordinance, and suitable arrangements have been made in place. The purpose of the exercise is to regulate the electoral arrangements such that we can, as far as possible, retain the original electoral arrangements that are familiar to the Changchao and Pengchao residents, including the number of electors, the electoral registration, and voting arrangements. So the VREO was renamed Rural Representative Elections Ordinance to concurrently cover the 2 types of rural representatives in future electoral elections, that is VR elections and KFR elections. Mr. Chen Hangbang would like to keep the term VR, that is village representative. We conducted a detailed study on this. The indigenous villages and their numbers, IRs, and the number of seats, as well as the electoral system would not be changed. The VRs, IIRs, in terms of expressions, the RRs, etc., would be retained in the law, and their respective roles and functions would not be changed. And then there are also statutory electoral arrangements for rural representatives. Such are not related to rate exemption, new territories, small house interest, and hillside burials. As I said to the bills, as I mentioned last November in moving the second reading of the bill, I mentioned the same. We did consultation and sought consensus between the government and Hung-yip. We discussed with the panel and obtained their support. We got support from the EAC, the Islands District Council, and the Chun-yan and Pengchao Rural Committees as well. The Bills Committee agreed to the proposals in the bill as well. We also considered that the main purpose of the bill is to regulate the Chun-yan and Pengchao KFR electoral systems by regularizing that by law. Such systems and the KFR roles and functions are familiar to the residents. Therefore, the existing proposal is most appropriate. As Mr. Kwok-him said, during the meetings of the Bills Committee, we discussed whether or not Changchao should be considered an indigenous village and expanded number of seats should be implemented. And we had discussions. Although this is not related to the regulation of KFR elections and is outer vires, we did study those arguments in detail and explain to the Bills Committee the government's position. In actual fact, the Village Representative Elections Legislation Miscellaneous Amendments Bill 2009 did conduct a detailed discussion on this. The government maintained the same position. There's insufficient evidence and justification to indicate that Changchao should be considered an indigenous village. According to the legislative intent of this bill, only those villages already in existence in 1898 in the NT, where VR system had already been in place in 1999 when the last round of VR elections was held before the enactment of the VREO, should be included as indigenous villages under the VREO. For Changchao, there's not been any strong evidence to show that it is an indigenous village. And Changchao had never had any VR electoral system. According to the gazetted notice, there's no evidence that Changchao is an indigenous village with village representatives. The local community ordinance regulates that notice. That ordinance is to differentiate the new territories into various districts to facilitate management and regulation. That has nothing to do with the VR electoral system. And the representatives elected then were not the indigenous village. In 1910, that was repealed. In 1991, the Hung-yip participated in the list of established villages in new territories jointly compiled by the government and the Hung-yip in 1991. It was clearly shown that both Changchao and Pengchao were market towns instead of villages, and the block lease of land on the NT normally contains the names of villages alongside the names of landowners. However, the block lease of Changchao and Pengchao does not contain any village names, and Changchao and Pengchao are not included in the list of recognized villages under the NT small house policy. And the existing constitution of Changchao Rural Committee provides that the Rural Committee is made up of 39 KFRs, and there's no evidence showing that any VR system exclusively for indigenous inhabitants has been held in CC. All in all, whether or not Changchao had ever been a village should not affect the amendments under the present bill. Besides, in accordance with the proposals and support of the Bills Committee, later move certain technical amendments in the committee stage to clarify the ordinance or the bill. Then we'll proceed to compiling the electoral roll, identify suitable polling stations, and to facilitate the next election early next year. Will seriously consider Mr. Andrew Leung's proposals. If the bill is enacted, the KFR elections will be perfected. With these remarks, I urge members to support the bill as well as the CSAs that I am going to move later in the committee stage. And now the question to you, and that is that the Rural Representative Election Legislation Amendment Bill 2013 be read the second time. Will those in favour please raise their hands? Those against please raise their hand. Mr. Albert Ho claims a division. The division bell will ring for 5 minutes.
開始表決。
Voting begins. Members, please check your votes. If there's no question, voting is now closed. Display results. Voting results: 60 present, 39 for, 3 against, 17 abstentions. The question is agreed by a majority of the members present. I declare the motion passed. Rural Representative Election Legislation Amendment Bill 2013. Committee stage. Council is now in committee. I now propose the question to you, and that is that the following clauses stand part of the Rural Representative Election Legislation Amendment Bill 2013. Clauses 1 to 21, 23 to 26, 28 to 36, 38 to 46, 48, 50, 51, 56 to 61, and 63 to 79. Does any member wish to speak? I now put the question to you, and that is that clauses 1 to Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Clauses 22, 27, 47, 52, 55, and 62. Secretary for Home Affairs. Mr. Chairman, I move the amendments to the clauses read out just now, the contents of which have already been set out in the paper circularized to members. All amendments are just minor textual amendments, in accordance with the suggestions of the Bills Committee, and has obtained support from the Bills Committee. The purpose is to clarify the text of the bill and will not affect the substantial contents of the bill. I urge members to support the amendments. Does any member wish to speak? I now put the question to you, and that is that the amendments moved by the Secretary for Home Affairs be passed. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the amendments passed. Clauses 22, 27, 47, 52, 55, and 62 as amended. I now put the question to you, and that is that clauses 22, 27, 47, 52, 55, and 62 as amended stand part of the bill. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Clauses 37, 49, 53, and 54. Mr. Albert Ho has given notice to move the amendments to clauses 37, 49, 53, and 54. Mr. Albert Ho. Chairman, I move the amendments to the clauses read out just now. As I said in the second reading debate, under the existing KFR electoral system, a block vote system is adopted. In Changchao, there are 39 seats. Every Changchao elector can cast 39 votes or choose 39 candidates. Under the law, they can choose less than 39 candidates. On Pengchao, they have 17 seats, so Changchao residents can vote for at most 17 candidates. Given this block vote system, we're very experienced, or rather agonizing experience. Well, that's the same for the NPC election, is a block vote system. So sufficient number of votes have to be cast. In the past, for the EAC, is the same. In the nominating committee of the CE election, the same applies to the sector of district councils. So with a block voting system, if you obtain a majority, you'll be able to obtain all the seats. This is not conducive to a pluralistic system. In particular, for places like Changchao, where a lot of Kaifeng affairs are to be handled, why can't we allow independent individuals who do not belong to the very forceful associations on Chang Chao to participate. For organized electoral campaigns under certain candidates, the electors very often choose 39 candidates. In Chang Chao and Chang Chao, I talked to some residents or inhabitants who had took part in elections. They did not belong to rural committees of Chang Chao and Peng Chao, or rather, they are not supported by those rural committees. So even though they have public support, they were defeated. Occasionally, they might have won, but that's just a coincidence in which the other strong parties just let them off the hook, so to speak. So there's no equal chance of participation. There are problems here. Number one, for the existing rural committees, for the incumbent members, the system favors them. They can continue with their seats. And besides, for those very influential parties, every person on Chang Chao, candidates I mean, can have $30,000 for electoral expenses. If you can pool together all the 39 candidates, you can see how huge the electoral expenses will be. But if you are alone, an individual, how can you compete with them? During the deliberation of the Bills Committee, some people said, well, we did discuss whether or not we should have different constituencies. And then some people said it's not good for Chang Chao, which is so small. It's difficult to have many constituencies. Although on Chang Chao, in reality, there are 2 constituencies. Yet, during the deliberation of the Bills Committee, colleagues said that there shouldn't be different constituencies. So, they're self-contradictory, because in any case, Chang Chao already have more than 1 constituency. Anyway, the number of votes will be reduced. For Chang Chao, the number of electors, 8,000 odd. If it's divided into 2 or 3 constituencies, you won't be talking about very few votes. Anyway, I'm not really in favor of constituencies. I'm more in favor of something like a proportional representation. That is, multi-seats, but there's no restriction that you should cast the same number of votes as the number of seats. It's just like the electoral election. Even if we have 9 seats, you can cast just 6 votes. You can just choose 6 candidates. I think that modus operandi will allow certain voices on Chang Chao and Peng Chao, representative voices, to enter rural committees. My suggestion is that we should set a restriction of 1/3. That is, the number of votes cast should not be more than 1/3 of the number of seats. Many pro-establishment colleagues said that, well, the system has been in place for a long time. During the consultation period, there's not much opposition because, of course, the rural committees were consulted and they considered the existing system quite good. So this is laughable. You consulted those with vested interest. The existing system is to their advantage. They would, of course, want the system to continue. There's no incentive for a change, no motive for a change. Will they allow representative voices, though minority voices, to enter the rural committees? Are they so broad-minded? I don't see such evidence. When we listen to public opinion, the villagers, particularly the indigenous villagers, were very angry. They said that the whole consultation focused on rural committees. the residents were not consulted. So these people who are rooted on Changchao, well, the families were rooted on Changchao for over 100 years, just like the descendants of Wang Wai Zhang. Their ancestors were in Changchao before 1898, but then they have no representatives in the Changchao Rural Committee. They could not win. So precisely you can see that the system is unbalanced. Therefore, Chairman, our suggestion is we hope that by restricting the number of votes to be cast by the electors, we can adopt something like proportional representation. That is, with multi-seats, but you cannot cast a similar number of votes. That is to ensure that some people who are representative to a certain extent can successfully become KFRs and enter the rural committees of Changchao and Pengchao. That's a fairer system. I really can't see we can accept opposing arguments, because their arguments have no degree of accommodation and are unfair in reality. So here, I'd like to make it very clear that if my amendments are unreasonably negative, the Democratic Party colleagues and I hope the other pan-Democrats as well, can indicate our attitude on this unreasonable block voting system to oppose the opposition.
Members may now debate on the original and the proposed amendments for clauses 39, 40, 37, 49, 53, and 54. Who would like to speak? Mr. Lang Chi-chang. President, with regard to the Rural Representative Election Legislation Amendment Bill 2013, we have now entered the third reading, and Mr. Albert Ho has moved amendment to these clauses. And in Changchao, we only have Kai-fong representatives, but then they are similar to village representatives, and they are members of the Rural Committee. And the Kai-fong representatives also serve the functions of residents' representatives, and of course they are representing Changchao residents or Pengchao Rural Committee, and they can also express their views. But then as Kai-fong representatives do not have a legal basis for their elections, that's why there have been complaints, and they even file election petitions, and the district officer had to make a ruling, and as there was no legal backing for this, that's why there was no way that they could verify the eligibility of the voters. That's why under the RREL Amendment Bill 2013 is not a complicated piece of legislation at all, and the focus is on the change of the name from VREO to RREO, so that Pengchao and Changchao Kai-fong representative election would be incorporated under the village or rural representative election system, and the number of candidates, and also the eligibility of voters, and also how the votes or ballot paper, how the votes should be cast and counted, and also electoral expenses and so on. All these would be put under regulation, as the purpose of the bill is to regulate the Changchao and Pengchao election in order to enhance the fairness of such elections. So I think this is something good as far as the representatives and the administration are concerned. And in the course of our scrutiny of the bill, and also during our public hearing, some Changchao residents said that the amendment bill had deprived them of their status as indigenous inhabitants of Changchao, and they even pointed out that the Changchao Rural Committee had not consulted the residents groups and the residents themselves. I've actually arranged for Cheung-chau residence representatives to have a meeting with the Home Affairs Department and the district office so that there could be more communication between them. The administration has repeatedly said that in accordance with the information available, the indigenous villages system were not in existence in 1898. Well, Mr. Leung, you should have expressed your views in the second reading debate. We are now discussing clauses 37, 49, 53, and 54, and the amendment moved by Mr. Albert Ho. You should have spoken on those issues. I think these are related. That's why I have to state the historical background to this. Well, I'll be brief in my submission. With regard to Mr. Albert Ho's amendment restricting that, that would be confined to the market town elections in Cheung-chau and Peng-chau, and if they can only elect no more than 5 representatives, and for voters they can only cast 1 vote for 1 candidate, and if they want to elect more than 5 Kai-fong representatives, then the only thing for them to do is to elect no more than 1/3 of the candidates standing for the election. At present, Cheung-chau has 39 Kai-fong representatives and Peng-chau also has 17. So, all along, Cheung-chau and Peng-chau are single constituencies, and they also have this block vote system in place. In other words, they have multi-seats and multi-votes. So, Cheung-chau residents or voters can cast up to 39 votes, and for Peng-chau they can cast up to 17 votes. It's an well-established and time-honored system, and it's also in line with the principle of democracy and fairness, and the bill is to regularize the system and also to ensure that the number of seats and also the voting method would be consistent with what has been in place. And Mr. Albert Ho's amendment would also affect the well-established voting habit of the electors. At the same time, it will also give rise to another problem. That is, how are we going to redemarcate the boundaries for this constituency? So I believe that this amendment should not be supported. These are my remarks. Thank you. Mr. Ip Kwok-him. Thank you, President. Concerning the election system, the so-called block vote system, 13, 9, and 17 respectively for Cheung-chau and Peng-chau, in the course of scrutinizing the bill, there was a very comprehensive discussion on this. Yes, we did not spend a lot of time on this, but then we have clarified this on some occasions. Well, Mr. Albert Ho referred to the NPC election. I'm also an NPC delegate. Well, yes, we have adopted this block vote system, but then this cannot be equated to that adopted for the NPC election. Well, I don't know how you might call it, but then in the NPC election, you cannot cast votes that would be higher in number than the number of seats available, and you cannot cast anything less. But then in this case, you can cast 1 to 39 votes or 1 to 17 votes. So it's up to you to decide how many members you'd like to vote for or how many candidates you'd like to support. So, and of course, you are not supposed to vote for more than 39 or 17 candidates respectively for Cheung-chau and Peng-chau. So it's up to the individual voter to decide. He can exercise his right as an elector. So he can cast up to 39 and 17 votes respectively. But then according to Mr. Albert Ho, this will create some unfairness. Well, no system is perfect. But then he also said that some independent candidate might not win an election. But then in the process of the scrutiny by the Bills Committee, well, this issue was raised, and the administration did provide us with the relevant information, and it also set out what actually happened on the ground. And in the 2010 election, there were 3 independent candidates with no particular affiliation. And of course, they cannot pull together their votes. So 3 did not have any political affiliation. And out of the 3, 2 lost the election. They only got 154 and 54 votes respectively. For the other one, he managed to win the election. He managed to get up to 653. So that was the situation back in 2010. So this candidate who managed to win, well, in our consultation or at our public hearing, he also came and he also told us his views. And he felt that there was no unfairness at all. And he actually told us how he managed to garner the support of the electors, and he was successful. So if you just say that because of this particular system, and as a result, independent candidates with no particular affiliation might not be able to win an election because of the lack of recognition by electors. That's not true, because in this case, we have seen a successful case. And also, for the pooling arrangement, so that they could also enhance the effect of publicity by pooling together the electoral expenses. Well, of course, in the case of district council elections, we had different constituencies, but then I've also known candidates who might pool together their resources. I think I could remember there were groups from certain institutions. So they would put together their resources, and they would have this link arrangement. So it's one of their electoral strategy.
And I don't think this will really bring a lot of advantages or benefits. Mr. Albert Ho has proposed this amendment. There hasn't been too much discussion in the Bills Committee. Well, in fact, when the Bills Committee decided to wrap up its work, Mr. Albert Ho said that he still had to consider what the amendment should be. And may I ask why it's 1/3, not 1/5, not half? Isn't that really too arbitrary? And what if an elector likes 38 out of the 39 candidates? So in deciding whether to support Mr. Albert Ho's amendment or not, members need to consider this point. And I don't think this proposed arrangement is like the proportional representation system. And the DAB cannot support this amendment, which represents an arbitrary decision. Dr. Leong Ka-lok, I haven't been following this issue. But then I want to say something in response to what Mr. Albert Ho has said. Now, concerning the block vote system, this is something we need to deal with. And then concerning medical council representatives, there are 7 seats which are returned by direct elections by the 12,000 doctors. Say, what if there are 3 seats and there are 5 candidates? The medical council adopts a block vote system. All 12,000 doctors can vote, and if there are 3 seats, then a doctor can cast not more than 3 votes. So the arrangement is the same as that in the bill. Now, in fact, all 12,000 doctors support the medical council's voting system. The block vote system has been in place for many years. And with a block vote system, does it mean that the election will be dominated by certain groups? I don't think that has been the case. So where does the difference lie then? Now, the difference lies in this. All 12,000 doctors exercise independent thinking. In other words, the 12,000 doctors are not influenced or controlled by others. There is no single person who can control all 12,000 doctors or who can control a majority of the 12,000 doctors to vote for a particular candidate. So if electors can all exercise independent thinking, if no one can exert influence on a majority of electors, then there is no problem with having a block vote system. In other words, each elector casts his or her votes independently. And why is it that the Democratic Party has painful experience concerning district council elections and NPC elections? This is because the number of electors is smaller, a few hundred or 1,200, and they do not exercise independent thinking, maybe. In other words, there may be people who can influence the voting preferences or inclinations of the several hundred or several thousand electors, and as a result, all the votes or most of the votes will go to a certain group of people. So, Mr. Albert Ho, if you want me to support your amendment, you have to tell me or convince or tell me whether all the 8,000 electors in Cheung exercise independent thinking, or whether a majority of the electors in Cheung will follow the voting preferences of some other people. So perhaps you should tell me the nature of the 8,000 voters in Cheung. If they all exercise independent thinking, then a block vote system is all right. Mr. Kwok-him, yes, I forgot to talk about the district councils. Now concerning the DC constituency 1, we haven't had this before. And in fact, previously there was the single transferable vote system. That was not the block vote system. So I just want to clarify that this is a different arrangement. Does any other member wish to speak? Secretary for Home Affairs. Chairman, I hope that members will oppose Mr. Albert Ho's amendment. Mr. Albert Ho has given notice to move amendments to clauses 37, 49, 53, and 54. The purpose is to cap the number of votes that an elector can cast in a Kai-Fong representative election. And that would mean that the voting system that has been in place for many years and has proven effective will be changed. And also the number of candidates that voters can choose will also be limited. As I said in the resumption of second reading debate, the purpose of the bill is to legislate, to regulate the Kai-Fong representative elections in Cheung and Ping Chau, which have a long history. And at the same time, we need to fully respect and preserve the various election arrangements that candidates and electors are familiar with, and these will include the voting system. Now, in fact, Cheung Chau and Ping Chau electors have been using this voting system for a long time. In other words, each elector can vote for a number of candidates not exceeding the number of Kai-Fong representatives to be returned at the election. This voting system has been operating well and has been serving Cheung Chau and Ping Chau well, and the candidates and the electors are all very familiar with the voting system. Now we in fact have consulted the Kwok and the rule committees. We've reached a consensus, and the Kwok and the two rule committees have written to the Bills Committee expressing support for the existing voting system. And on the 6th of January, when there was a meeting with the administration and deputations. The Bills Committee noted that many of deputations supported the proposal. Now, in fact, concerning this voting system, we can have fair and free rights to nominate, to take part in elections, and to be elected. And in fact, independent candidates enjoy the same chance to get elected. As Mr. Lau has said, the block vote system is also used in the medical sector. Electors can cast a maximum of 39 or 17 votes, but at the same time they can cast a fewer number of votes, or they can only vote for one candidate. So the voting preferences of the electors can be better reflected, and usually under this voting system, those elected are able to get quite a large number of votes, and as a result, they are representative. And so we are of the view that the block vote system has served Ping Chau and Cheng Chau well, and the voters are familiar with the system, and the voting system is in line with the principles of democratic elections. And concerning Mr. Ho's amendment, then under this amendment, a number of candidates that voters can choose will be limited, and as Mr. Yip has said, an arbitrary percentage has been set, and that arbitrary percentage reflects only his preference, and the Bills Committee has not had a chance to discuss the amendment in detail. We are of the view that the views of the Kwok, the two rule committees, and the electors should be respected. We are of the view that the voting method, which has been in use for a long time, should be retained. Thank you.
Mr. Albert Ho. Mr. Chairman, right from the beginning, the Secretary said that the existing system is well established. I think this is a typically conservative remark. Well, things have gone well. Why we should change it? But if something is unfair, then we should change it. That is number one. Secondly, as I said just now, during the consultation period, the government only concentrated on consulting the rural committees. The government did not consult the Chang Chau residents. Therefore, the government did not duly listen to community opinion, in particular those opinion about the existing system. That's number two. Number three, I now suggest that we should restrict the number of votes cast. We did discuss this. In the Bills Committee, we discussed the possibility of having constituencies as well as the possibility of restricting the number of votes to be cast. But my proposals were not accepted. The pro-establishment colleagues would like to retain the existing system and protect existing interests. That's their sole consideration. So that's meaningless. You now criticize my amendments, but you did not consider those amendments. In principle, you vetoed those amendments. Why a third? Let me respond to those remarks on that point. And when doing so, I'll also respond to Dr. Leung Ka-lau's views. Just now, the Secretary quoted Mr. Leung Ka-lau's remarks by saying that the doctors adopt the same system. For a block vote system, if you are voting for something like an executive committee, I can agree with you, because you're talking about the same work. Say 6 votes or 7 votes for returning people to discharge similar duties, just like those of an executive committee. As you said, you would like to have cooperation, you would like to have team spirit. So very often we have a block vote system for, say, a cabinet election. But now we're talking about electing representatives for 39 seats. And among those 39 people returned, they may be subdivided to take care of the kaifongs of different areas. Now, these 39 people are representatives of public opinion. If we are to adopt the block vote system, the result is that you only have one single type of opinion, because through your existing organizations and existing influence, through their financial capacity or capabilities, well, bear in mind, they can jointly support the same candidates. Therefore, the result can be lopsided, maybe 35, 36, 37, or even 38 candidates returned may come from the same camp, but maybe just one different individual can be elected. So that's different from voting for one single body. Now, why 1/3? For Chun Chao and Peng Chao, number one, at the moment, the Hung-yi caucus of force, including the DAB and the rural committees, the pro-establishment camp, is a very influential camp with actual political strength. That's one phenomenon. Secondly, those who came to air their grievances, the indigenous residents, they belong to another group. I don't know how many of them there are, but they have properties, descendants and elders still living on Chun Chao or Peng Chao. The third group comprises those who are not the existing forces. Neither are they indigenous residents. They've moved to Chun Chao. They're familiar with the affairs there. They're concerned about the environment there, etc., etc. So there are three groups of people here. That's why I propose 1/3, because it's good to have representatives from all the three groups. So representatives of public opinion as such will be able to air the views of all three groups. However, the pro-establishment camp is not interested in my proposal. They say the existing system has been well established, it's quite good, so they would like to continue to monopolize the election such that their interests can be protected. Now, in principle, we have to effect a breakthrough. Even though we have insufficient votes, we still have to move the amendments. If possible or necessary, we'll oppose the third reading of the bill. And I'll put the question to you, and that is that the amendments moved by Mr. Alberto be passed. Will those in favor please raise their hands? Those against, please raise their hands. Mr. Alberto claims a division. The division bell will ring for 5 minutes.
開始表決。
Voting begins.
請各位核對表決。
Please verify your votes.
如果冇問題，現在停止。
If there are no questions, voting is closed and the results are displayed. Those from the FC, 27 present, 7 for, 19 against, 1 abstention. Those returned from the GC, 32 present, 16 for, 15 against, no abstention. The question is not agreed by majority of the 2 groups of members present. I declare the amendment negatived. I now put a question to you, and that is that clauses 37, 49, 53, and 54 be incorporated into the bill. Will those in favor please raise their hands? Those against please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Schedules 1 to 5. Does any member wish to speak? I now put a question to you, and that is that Schedules 1 to 5 stand part of the bill. Will those in favor please raise their hands? Those against please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Council now resumes. Third reading. Rule Representative Election Legislation Amendment Bill 2013. Secretary for Home Affairs. President, the Rule Representative Election Legislation Amendment Bill 2013 has passed through the committee stage with amendments. I move that this bill be read the 3rd time and do pass. I now propose the question to you, and that is that the Rule Representative Election Legislation Amendment Bill 2013 be read the 3rd time and do pass. Does any member wish to speak? I now put a question to you as stated. Mr. Kwok-him, I'd just like to make a brief statement because, during the second reading debate, I heard that many members talk about Wai-hing and also some indigenous inhabitants. Because of the passage of this bill, they would not be eligible to become rural representatives representing indigenous inhabitants. According to my understanding, even with the passage of this bill, nothing will be changed. Well, for Cheung Chau and Peng Chau residents, if they are able to come up with new evidence to prove that the relevant requirements are in line with the present regulations, then they will still be able to do what they'd like to do. And even under the existing arrangements, that could still be done. So when we scrutinize the bill, we were also very clear about this. So please do not use that as an excuse to block the passage of this bill, because this bill has the sole purpose of regularizing this election system. Yes, Mr. Kwok-hung. Since Mr. Yip has spoken, I'd also like to speak about this. Well, as an elected member, well, we have heard the views or submissions from the deputations and views from the indigenous inhabitants and so on. I believe that there is no reason why this should be done. That's why I'm against the third reading of this bill. Mr. Kwok-him is suggesting that if you're able to come up with new evidence, then of course you can be included. Yes, I can understand this. But then I'm of the view that the evidence that has been presented is already sufficient. Or if you say that 2017 is not okay, then you can change it in 2020, 2021. Well, it's a waste of time. Actually, what we're talking about is what needs to be done right now. So, Mr. Kwok-him, so what's your view on the evidence that has been presented before you? And if you think that it's already sufficient, then why are you backing the administration up? So why can't you ask Tang Tak-sing, the Secretary for Home Affairs, to make concessions? All right, if he's prepared to accept what's been presented before him, and if an amendment can be made, so will that result in the subsidence of Cheung Chau or Hong Kong. So even if you have any skepticism, well, given the fact that this is just a rubber stamp, I think that we should resist that. That's my view. It's as simple as that. All right. You were just saying that, well, whatever has been in place should be kept the way it is. So, Chang Tak-sing, why don't you just ask yourself this question? Well, even if the evidence that has been presented is not 100% substantiated, what's wrong with changing it? Who will suffer? Who will suffer adversely? I'd just like to remind members that under Rule 63 of the Rules of Procedure, well, in third reading, members' remarks can only cover or can only be on the substance of the bill. Well, my point is that there is sufficient reason for me to vote against it, and I urge other members not to listen to what Mr. Kwok-him just said. So we should just reject the bill, and then we could start it all over again. So it's like the budget. If we can reject it, then there is no need for us to filibuster. So do you dare to vote against it? Well, in simple terms, even if the administration promises that with new evidence, they would be prepared to give it a second thought. So we can establish a system with indigenous representatives voting system. But then that led me to abstain in the second reading of the bill. But then as the voting system is not fair, as our amendment has not been passed, so that would already give us sufficient reason for us to vote against the third reading of the bill. All right, does any other member wish to speak? Mr. Albert Chan? Well, Mr. President, I think it's ridiculous for us to argue whether or not they have presented us with sufficient evidence. All right, you can say that based on the existing situation, because of the interest of the group that you support or you belong to, well, you will have to serve their interest. That's why you have to ensure that this bill is passed intact. Well, I can understand this. But then if you say that there is not sufficient evidence to support their argument, that's why you have to bulldoze this bill through this council. I think you're calling, you're actually not doing justice to this. Well, we should have established that Wai Chak Tong's descendants are indigenous inhabitants of Cheongchao. I think nobody, including government official, can deny that. So given the fact that there is already a prima facie case, and if you look at case law and literature, actually this is an objective fact. And if it's an established fact, and if it's a fact that indigenous inhabitants' status have not been included in the bill, then that is an omission and inadequacy of the bill. That's why People's Power already voted against this in the second reading debate. In fact, all pan-democrats should have voted against it because the bill is flawed with problems. You should not have abstained in the second reading debate, but then this is already history. But then because of the flaws in the bill and inadequacy of the bill, I think Lau Wong-fat should have voted against it in the third reading because this is a disrespect for indigenous villages. I think this is an omission for the indigenous residents. Who would like to speak? Secretary, would you like to speak? No? I'll now put the question to you. And that is the Rural Representative Election Legislation Amendment Bill 2013. Be read the third time and do pass.
I now put the question to you as stated. Will those in favor please raise their hands? Mr. Leung Kwok-hung claims a division. The bell will ring for 5 minutes.
開始表決。
Voting begins.
請各位核對。
Members, please check the votes you've cast. If there are no queries, voting is closed. Please do not shout from your seat. If you have any queries, please raise your hands. Members, please check the votes you've cast. If there are no queries, voting is closed. The results are displayed. Members present 58, 35 for, 21 against, 1 abstention. The question is agreed by majority of the members present. I declare the motion passed. Rural Representative Election Legislation Amendment Bill 2013.
We now resume the second reading debate of